I want to talk to you about joint employers. Sometimes you will work for one company in one aspect and then another company on another one. So maybe you serve as a security guard for company X during the day, and then in the same facility using the same uniform, you're doing it for company Y at night. And they're both coordinated companies. They do much of the same thing. They have different corporate structure, but in terms of what you do and the work you do, you are essentially doing the same job, and you are jointly employed by both of them. So this can have impacts in employment law, and they don't say that necessarily. They don't say, hey, you're jointly employed by us. But this will have some impacts in employment law in a couple of areas. So one is to bring a charge of discrimination in federal law, you have to have at least 15 employees. And sometimes employer A may not have 15 employees, but employer A and B together, because they're considered joint employers, will have the 15. And so therefore you can file the charge. Another example we see is with overtime. So there was a recent case where a waiter worked for a company A, waiting tables, and then company B in a members only area. Still doing the same thing. They're separate companies, but she's still doing the same thing, still using the same uniform and all that, working, let's say 20 hours, for company A, and then let's say 30 hours for company B. And she wasn't getting overtime, right? Because you have to work over 40 hours generally to get overtime. And she sued, and the Department of Labor said, yeah, you are a joint employer for the purposes of the Fair Labor Standards Act, which is the law that governs overtime, because you guys are essentially joint employers. I mean, you have separate corporate structures, but she's doing the same work in the same place, using the same equipment. So for her purposes, you guys are joint employers. And so we're going to add those numbers up. And so she hasn't been getting paid for all this overtime. And that can be significant. If you've got a Fair Labor Standards Act claim, you can get back pay, sometimes double back pay. You can get your attorney's fees paid for. It's a serious statute. And if you've worked the time, you're entitled to get paid for that overtime. So keep in mind the joint employer issue that can be fairly complicated. So it's worth talking to a lawyer for, because it can mean that you might not have a claim against one company A or company B, but because they're considered joint companies, you've got a claim against company AB. So if you're in kind of one of those situations, just because they're separate corporate structures, if you think, hey, you know what, I might actually be essentially working for both companies, go talk to a lawyer. This can be pretty complicated, but it could mean that you have a claim that you wouldn't otherwise. So don't forget the joint employer issue.